Congress enacted this principle that you shouldn't be fired because of who you are, whether it's sex or race or nationality or religion. All of those are covered in Title VII. And so what does that mean?
Welcome to the Contrary. This week, we continue our Women Thought Leader series. We are here with Georgetown University Law Center Professor Nan Hunter, who is an expert on women, gender, and the law. Welcome, Professor Hunter. Very nice to meet you. Thank you for coming.
My pleasure.
And we're going to do this sort of backwards in the sense that you have a new finding, which is fascinating, which I want to talk about. But then I also want to talk about the whole history of, laws, judge-made, meaning court opinions, congressional-made law, which is seen as something different, and what it means and how it has evolved over time in re LGBTQI rights. Mm-hmm. So we start with your finding. Please tell me what that is.
Well, what I wrote about was something that I found in the the JFK Library in Boston when I was doing research for, a different project. And what I came across was something that speaks directly to what the sort of understood meaning of sex discrimination was in the mid-1960s. Because that's the question that is before the court in these Title VII cases. What does it mean when Congress enacted Title VII to say there can be no discrimination because of sex in the workplace? And it was the 1960s. And what courts look to now in interpreting text is if there aren't committee reports, and there weren't for this particular part of Title VII, what was the popular understanding? What were people thinking about when they thought about discrimination based on sex? And I think the right answer to that is that even in 1964, discrimination based on sex included concepts like stereotypes and gender. And here's the evidence that I found of that. It was the transcript of a meeting of what was then the President's Commission on the Status of Women. This is 1962, so it's actually a couple of years before Title VII was enacted. And the conversation is how irrational it is to distinguish based on sex when people are doing the same job. So it's an equal pay conversation. And the chair of the committee on law of this commission is a woman named Edith Green. She's a member of Congress. She came from Oregon.
A Democrat.
A Democrat. She was in Congress for 20 years. She had been a school teacher. She was a wife, a mother.
And sounds like an earlier version of Patty, now Senator
Patty
Murray, when she first campaigned, talked about being a mom in tennis shoes.
Yes. Edith Green is chairing this meeting, and this question comes up: how can people not get it that it's discrimination based on sex, and when people are doing the same job? And Edith Green says, well, if you want to hear about sex discrimination, let me tell you about sex discrimination. And that occurred in London when a woman who was working for the British ministry, so it's just the British government. It's not some obscure little, mom and pop business somewhere. The British government. She's working for the British government. She decides she wants to transition and become a man. So she changes her name. She goes through the process. She informs the employer that she'll be coming to work with a new name. She'll be coming to work as Jonathan. She comes back to work as a he. She starts work and doing the same job, and bingo, she's got a raise. Why is there a raise? There's a raise because now this person is male, and men get paid more in the early 1960s in Britain. And so the structure of that story It's exactly the same structure as the story of the cases before the Supreme Court. In the Supreme Court, one of the cases involves a man who transitioned to become a woman, felt like that was her true gender identity. Comes back, tells everyone, comes back to work, same job, same person, same employer. Everything is the same except that this individual's sex has changed. And so the argument about whether that constitutes discrimination based on sex, if you think about it in simply a logical, kind of common sense way, it's obviously discrimination based on sex. And
it's fired, right? It's fired for that.
And it's fired, that's right. So 1962, becoming a man gets you a raise, and today, if one transitions to become a woman, you're fired. But the issue, I think, is just the logical structure of it. And so was that same logical structure kind of in the minds of people in the 1960s? And the story from this President's Commission, I think, illustrates that it was. That you had a room full of professional men and women who were considering this issue. They hear this story. The story is actually told by a member of Congress, even though it isn't a congressional committee. And I think it simply illustrates that the logic of sex discrimination then, when someone took the trouble to think about it, was the same logic of sex discrimination now. And so I think that's important for us to remember as we think about questions of sex discrimination that are raised by people who did not tend to be plaintiffs in the 1960s, such as gay people or transgender people.
Let me play devil's advocate for a moment. I mean, you're talking about a conversation that took place outside of a hearing, I guess.
Outside of Congress.
Before or after the actual hearing itself, or was this did she tell this anecdote while they were in some kind of official?
Oh no, this was part of the official hearing.
Okay.
That was the meeting of the commission.
But still, and she later voted, by the way, for the Civil Rights Act.
Yes.
As did most Democrats back then. But getting back to her story, it wasn't in a conference committee where the House and the Senate work out differences between the two bills, two versions of the bill that they both pass. Then the conference committee, as it's called, passes the legislation. Then it's sent back to both chambers for another vote. So it wasn't, and usually those are the kinds of things that when the Supreme Court, when any courts are trying to look to figure out what is so-called congressional intent, they will look to something that happened at a committee that was directly involved in deciding what the Civil Rights Act should be.
That is true, but that is actually an older way of interpreting text. And most of the textualists today, including people like Justice Scalia, who wrote an interpretation of Title VII saying that it included not only sexual harassment, but sexual harassment of men by men. So same-sex harassment was also included in Title VII. And the reason for that is that courts now accept that we can't know what all the members of Congress were thinking or what they intended. They probably intended different things. But what we can try to think about is what was understood at the time. What reasonable people applying common sense to particular situations would have thought was included in sex discrimination. And based on that, the court has, over the past, 50, 60 years since the law was passed, it has extended it to cover sexual harassment, which is not mentioned in the statute. There's no mention of harassment. There was no discussion of harassment in the Congress. But we now take it as a given that constitutes discrimination based on sex, including, as Justice Scalia said, discrimination when a man harasses another man.
To our viewers, they didn't used to consider that sexual discrimination.
No, I mean,
because it didn't happen to a woman. Sex discrimination was something that harmed a female.
Again, if you sort of imagine, time travel, and imagine a sort of reasonable group of people thinking about sex discrimination and what it includes, and applying that to situations that are new. I mean, that's what law does all the time. We take a principle of law or a statute, new facts come up, and we try to determine what is the most reasonable and principled way to apply something like the rule against sex discrimination. And so, I mean, sexual harassment in 1964 was, watch an episode of Mad Men or something, right? I mean, it was like a day at the office, I mean, there was nothing.
Well, until 1972, the New York Times posted classified job ads separately. Help men wanted, help women wanted, and those jobs, it was perfectly fine to post the same job in both columns with paying less to the women because women it was accepted in society that it was fine to pay women less.
That's right, and so that there's so many examples of common practices that were alive in 1964 when the law was passed, that people didn't, necessarily think of immediately as sex discrimination, but when those situations were presented to courts or agencies like the EEOC, then yes, we take the principle. Congress enacted this principle that you shouldn't be fired because of who you are, whether it's sex or race or nationality or religion. All of those are covered in Title VII. And so what does that mean? What is it that happens to people because of sex or because of race? And so over time we've seen, initially the argument was that pregnancy was different from sex, that, there were pregnant people and non-pregnant people, and it just so happened that all the pregnant people were women. Isn't that amazing? And so Congress actually fixed that and amended Title VII, and now that's an accepted principle. And the court itself included sexual harassment, and especially, I think, relevant to these cases. The court has, and this goes all the way back, this goes back to Ruth Ginsburg's and her arguments, accepted that stereotypes of sex are part of sex discrimination. So there's a famous case from the late 80s, again, the Supreme Court ruling under Title VII, in which a woman, Ann Hopkins, was denied partnership at Price Waterhouse because, and this was in the record, what her supervisor said, she's not feminine enough. She doesn't walk the right way. She doesn't dress the right way. She needs to wear more makeup. She needs to wear more jewelry. She needs to go to charm school. And the court said, it doesn't matter that some other woman might have been promoted, right? What matters is that you are applying standards here to her because of stereotypes. And those stereotypes are clearly sort of sex-based stereotypes. They're about what a woman should look like or how she should act or how a man should act. And that, is another important concept for these cases that are before the Supreme Court now.
I grew up in a binary world.
Right.
You were a girl or a boy. And it was, even though I love change, I look forward to change as society evolves. I remember the New York Times ran an article, this has to be 15 years ago, about a boy, he was 7 years old, I think, in San Francisco, and who, raised as a boy, decided to told his parents, I'm not a boy, I'm a girl, I'm just in the wrong body, and they let him grow his hair long like a girl, dress like a girl like he wanted to. Eventually, I think, even talked about the changing hormones for him. And I must say, that's the first time I heard about anything like that, even though I grew up in New York City. Usually I lived that stuff before it got into the paper. But this time it was in the paper first. And so I remember being a little shocked about that. And that was sort of the beginning to me of when people started talking about, nobody is absolutely female or absolutely male. We all have a little bit of, women still have testosterone, men still have estrogen. So we're on this continuum as opposed to it being absolutely binary. So what were the first court cases dealing with those issues, the first major ones, and how did the Supreme Court rule on them?
Well, this is the first case involving a transgender issue that has gone to the Supreme Court. Now, lower federal courts have been dealing with transgender and gender transition issues for a while. In fact, the sex discrimination cases go back 20 years for federal appellate courts that were presented with facts along the lines of the facts that are at the Supreme Court now and the facts that came out in the British ministry in the early 1960s, and that is the transition of a person from one gender to another. Sometimes there have been requirements of medical consultations or medical treatments or sort of certification of the necessity of it, and that's come and gone in the law. But the law has recognized this as a matter of discrimination based on sex, actually going back 20 years. But it is true that the Supreme Court has never ruled on this question.
Talk about, if you will, a little bit the important rulings that Ruth Bader Ginsburg made when she was a lower court member of the appellate court, as opposed to the Supreme Court that had to do with sex and gender discrimination.
I think that one of the ways to understand what Ginsburg was arguing from the very beginning was in military cases, for example. I mean, she represented a number of women in the military, or in some cases men in the military whose wives had died or whose wives were not getting the same treatment as male spouses. And she took those cases to the point of the Supreme Court realizing that sex discrimination, like race discrimination, had to be examined very closely for whether it was rational and whether it served any legitimate purpose. And a big part of what she was arguing was that the assumptions that were behind those rules and those laws at that time were assumptions about women's inability to do certain things, and also assumptions about the roles that women played in the workplace.
In combat, women couldn't do
exactly
this job in the military or that job, and now almost no positions are forsworn for women in the military. They can do just about everything, including combat, even though the military in this it's been 20, 30 years, there were women arguing that women can't be in combat, even though I remember during the Reagan years there was a commission on women in the military, and conservative women were arguing women can't be in combat, they get their periods, blah blah blah. It's been a total revolution in terms of the military view.
It has.
So you're hoping in the upcoming Supreme Court case that was heard in October that the court will rule.
The court will rule that the phrase "because of sex" in Title VII includes situations where sex is taken into account, so that it expands beyond, just as the court has said, it expands to include harassment and not just firing somebody. That it includes, is understood to include situations where the reason I'm firing you is because you changed sex, or the reason I'm firing you is because I don't like the way you walk or talk or act. You, a man, are too effeminate, or you, a woman, are too masculine. I mean, the case that I described, the one involving the woman at Price Waterhouse, she has now passed away, Ann Hopkins, and because she was a litigant, a lot about her personal life became known. She was not lesbian. She was a heterosexual woman who was married. She had kids. In fact, one of her daughters signed an amicus brief in favor of the plaintiffs in this case. And when you think about that, one has to think, well, you go back to that point in time, and women in business, women who acted in an assertive way, what was considered too assertive in those times would not be considered that way now. And one of the, ways that people attack women who are viewed as too assertive or too masculine is to say, well, you must be a lesbian. You must be deviant in some sense. And so that whole method of holding women back, or policing men whose gender presentation is different from what we think of as maybe the more standard presentation. I mean, that is because of sex. And what I want the Supreme Court to do is to recognize that and to preserve Title VII as a really vital, robust method of protection for people.
And yet it's a Supreme Court dominated by conservatives. Now, of course, Scalia was a conservative, but how do you think you're going to do with the addition of Kavanaugh and Gorsuch, two extremely conservative, way more conservative in their politics, it seems, than Scalia, who, at least on free speech and civil rights issues, had some more moderate views. Like he wrote the "You Could Burn the American Flag," that's political speech case. Mm-hmm. And he was famous for not towing the conservative line on some issues. Do you think Kavanaugh and Gorsuch may turn out to be the same way?
Well, I think on this kind of issue it's possible because of the philosophy that Scalia, and they are, I believe, they both said they're great admirers of the late Justice Scalia. What he pioneered and what is now accepted is an understanding of what the text meant in the culture at the time. And I think when you give it an honest look and sort of not let the sort of culture wars of the last 30, 40 years sort of influence you one way or another. And you go back to little examples like Congresswoman Green, right? She wasn't making a point in the culture wars. They were just talking about discrimination based on sex and how crazy it was if you had the same person doing the same job. I think if you give it an honest sort of common sense approach like that, you can get to the position that this is fairly covered. That, as Justice Scalia once said, statutes should not be strictly construed or too broadly construed. They should be fairly construed, and fair based on a common sense reaction. So Gorsuch, for example, during the argument in these cases said, well, this is a very, very close case. This is, and I think he was saying, he didn't put it in these words, but it sort of runs against my conservative tendencies. But I see the argument. I get the argument here. And so I'm hoping that Gorsuch, the Chief Justice, and the other justices sort of stick to that perception and take it where they should take it.
Well, all the best of luck to you, Professor Nan Hunter of Georgetown Law School. Thank you so much for your time and for your thorough explanation of the origin of LGBTQ rights in court law and all the way up to the Supreme Court. Thank you very much.
Thank you.
I'm Bonnie Hervé. That's it for this edition of To the Contrary. Please join us next week, and in the interim, please tweet or Facebook post on our pages on Twitter, on Facebook, on the PBS website. And thank you for joining us. And whether you're in agreement or to the contrary, we'll see you next week.
Funding for To the Contrary provided by the Cornell Douglas Foundation, committed to encouraging stewardship of the environment, land conservation, watershed protection, and eliminating harmful chemicals. Additional funding provided by the Wallace Genetic Foundation, the Colcom Foundation, and the Charles A. Freoff Foundation. For a transcript or to see an online version of this episode of To the Contrary, please visit our PBS website at pbs.org/To the Contrary.
Be more PBS.